Hello and welcome to the Kenneth Rickham Law Office Legal Podcast, the NJ Laws Tube, looking at recent cases by the Supreme Court and appellate courts. And these are cases that were discussed at the seminar handling drug DWI and serious municipal court cases sponsored by the New Jersey Institute for Continuing Legal Education. Let's see. We first look at PTI, pretrial intervention. And let's say there's both criminal and traffic charges against someone. Let's say, can a guilty plea to the traffic summons be required as a condition for PTI? And the answer is yes in Sussex County in a snowmobile accident. Let's say the Appellate Division State versus Mosner, Mosner, held that PTI can be conditioned on a plea to a traffic offense. Now, I'm not sure if the opinion is correct because they said admission into the pretrial intervention program can be conditioned on the defendant's guilty plea to a motor vehicle offense carrying a mandatory 180-day term of imprisonment, where the defendant's attitude would render pretrial intervention ineffective. Now, this is despite PTI guidelines that prohibit a guilty plea as a condition of PTI, and it doesn't make sense because, aside from third offense DWI, there's no mandatory 180-day imprisonment. The 180-day term of prison is discretionary with the court. So either the Appellate Division is wrong or they just made it, maybe that was the terms that were required by the prosecutor's office. But the bottom line is that PTI can be conditioned on a plea to a traffic offense, at least in this opinion by the Appellate Division, State versus Mosner, Mosner, 407 NJ Super 40 Appellate Division 2009. Now, just about everyone is familiar with the Miranda warnings. You have right to remain silent. Everything you say can be used against you. Can a violation of Miranda be asserted by a co-defendant? And the answer is no, according to the Supreme Court in State versus Baum. In Baum, the court held the defendant passenger Moore's motion to suppress evidence found during a warrantless search of the vehicle in which he was riding should have been denied. The motion should have been denied because he did not have standing to argue that the driver's right against self-incrimination was violated and because the search was not unreasonable. That's State versus Baum, 199, NJ, 407, 2009. Let's see. Now, there's a statute that deals with obstruction of windows. And what's a reasonable belief of obstruction? I'd say, well, it depends. Let's say, in the case of State versus Barrow, the Appellate Division held a mere obstruction should obstruct the driver's view for it to be a violation. There, the court wrote a police officer stopping a motor vehicle for violating NJSA 39:3-74 must provide articulable facts showing that he or she reasonably believed that the object hanging from the rear view mirror obstructed the driver's view. In this case, it was mini boxing gloves that were hanging. So the question is, well, what about it? Other things hanging. Does that count as an obstruction? I'd say Easy Pass is required to be put in the front. What about a state police car camera in the front, which is required? That's unclear. But the site of its State versus Barrow, 408 NJ Super 509, Appellate Division 2009. Let's see. Community caretaking. Can the police enter a home without a warrant if there's a report of an unintended child? The answer is yes, State versus Bogan. The warrantless search of a house to check on an unintended child was permitted under community caretaking. The police officer's warrantless entry into the home for the purpose of taking the telephone from an unintended child to speak with his parent was justified by the community caretaking doctrine because the officer had a duty to identify a responsible adult for the child and to ensure his safety. Because the officer was lawfully on the premises when he observed in plain view the defendant, who fit a suspect's description, he had a right to direct the fellow officers to question the defendant, and that was State versus Bogan, 200 NJ 61, 2009. And lastly, let's see, is idling while drunk in a car and sleeping in a car DWI. Well, not in a farm in Hunterdon County. State versus Putz, unpublished decision by the Appellate Division, May 26, 2009. The defendant here appealed his conviction for driving under the influence of alcohol. The arresting officer observed and approached defendant's truck, in which the defendant was sleeping, that was parked with the engine running in a turnabout on private property. Because the record did not support a finding beyond a reasonable doubt that the defendant intended to operate his vehicle at the time of his arrest, the Appellate Division reversed the conviction. And that's State versus Putz, unpublished, decided 5/26/09. For additional information, contact the law office of Kenneth Verkaman, 732-572-0500. More information on the web at www.njlaws.com. That's njlaws.com, and benotguilty.com. That's benotguilty.com. Located at 2053 Woodbridge Avenue, Edison, New Jersey, 08817. Thank you, and good luck.